Hello, wonderful people. You're welcome to another great session. Hope you're keeping safe. Hope you're fine. Hope you're doing well. This is your girl Mercy, and I'm here to discuss a very important issue with you. Um, Welcome to Lawyers Info Hub. This is a platform where I reach out to lawyers, law students, anyone interested in law, because the tips I share, you know, serves both a lawyer and a non-lawyer. So today I'm going to talk about the legal implication of issuing a Dud check. Yes, a Dud check. Most people do not know the legal implication, and they're always caught in the web. And when there's an issue, they start running around. I thought I will have money in the account and all of that. So if you're ready to move, let's get it going. I would say that when people issue dot checks, and at the end of the day, it turns out to be a dot check, maybe originally they didn't have the intention of defrauding or not paying the application. But maybe because of one issue or the other, the check turns to become a dot check. And they are confused as to what can I do or how do I remedy the situation. If you're a returning subscriber to this channel, I appreciate you. Thank you for subscribing to this channel. Thank you for always stopping by to watch the videos. Thank you for your comments. Thank you for the DMs. Thank you for, you know, pushing me to create more content. It's been amazing for these few months. It's been an awesome journey. I appreciate you. And for you who is watching me now, you've not subscribed to this channel, please hit the subscribe button, hit the notification bell so that whenever I drop a new video, you'll be the first to know. Share this video to your friends, share to your loved ones, share to your colleagues, because the information I'm sharing here, it's something that everyone will want to enjoy. So not only you share to your friends, tell them about Lawyers Info Hub, and also like the video. Thank you very much. Now, when you hear about Dud check, this is a check issued by the drawer of the check, so someone without the person having sufficient funds in his or her account, that is able to sustain the drawing of the check. For example, I gave someone a check of 500,000 and I do not have 500,000 in my account. And I've presented to that person that I have the capacity to give you 500,000. Maybe I'm paying for goods or I'm owing someone, and the person comes, I just issue a check to the person, and in the person's mind, oh, I've got my money. But in my mind, as a drawer of the check, I know that I don't even have up to 500,000 in my account. But I have created a misrepresentation. I've created a situation of fraud, because I knew I didn't have sufficient funds in my account, and I went ahead to give the person a check, which by the time the person gets to the bank, he or she would not be able to um, cash the check. So friends, let's get to it. I've tried to explain what a dot check means, like when you issue a check to someone and there's no sufficient funds in your account, you know, so that the person can be able to withdraw this amount you're stating in the check. And by the time the person gets to the bank, the check will be dishonored because there's no sufficient funds in the account of the person who gave out the check. That's the drawer of the check. Now, with respect to a dot check, issuance of a dot check, it's all governed by the Dishonored Checks Offences Act. We have the Dishonored Checks Offences Act, Capital D11, Volume 5 of the Law of Federation of Nigeria. That's the LFN 2004. Dishonored Checks Offences Act. Many people have not come across this act because they've not had any issue to do so, or they are not interested, or they've not had cause to search for this law. We have this law, and most people have used this law to um, get back their money. Yes, because once a debt check has been issued and get check has been issued, I get to the bank and it was dishonored based on insufficient balance, then it has become a Dud check because it's there's an inference of fraud, deceit, misrepresentation to that person. Now, when someone gives you a check and say, please don't present this check till maybe the third day or ending of next month, and you present that check earlier than that time, and they said DAR on the check, the right DAR, that's the drawer's attention required, and you now claim you issued me a dot check. No, if there was a timeline given to you before a presentation of the check, and you go ahead before the timeline, you can't come and rely on this act or come and start screaming, I was issued a dot check, and no. It's only after the timeline or the person didn't give you a timeline at all and just presents the check to you like, I have sufficient funds, go and get your money. And you now get to the bank, there is an issue. Then this is when you can now rely on the Dishonored Check Offences Act, Cap D11, Volume 5 of LFN 2004. Now, the case of Fajemiroku against Commercial Bank Nigeria Limited, 2009, matters 2 to 3 Supreme Court um, judgments, yes, SC. Part 1, then at 26. When you read this case, you really understand the concept of issuance of a dot check. Now, when a person issues a dot check, the person is guilty of an offense and is liable to be sentenced to imprisonment for 2 years without option of fine. Yes, when a person issues a dot check, is has committed or he or she has committed an offense and is liable to imprisonment for 2 years without an offense, without an option of fine. But when it's a corporate body, maybe an association or a company and all of that, the company, will be fined not less than 5,000. Well, I would say this is one of the drawbacks of that law, which needs to be changed. We need to be, amended, to increase the fine to be paid by a corporate body. Now you now ask me to peradventure is I supplied my goods to a company, and the company, because they know that, well, at the end of it all, I'll just pay a fine of 5,000. I can as well take these goods, utilize it, and give this person or the supplier a check which he cannot cash. So I don't think I have anything to be afraid of. The law is that, in as much as the check was in the name of a corporate body, all officers who connived to issue that check is also in for trouble. Yes. Now, both the person, because it was written by someone, both the person or the person who connived to issue that check, be it the director, be it maybe the accountant or whosoever, or wherein there is negligence on the part of any official or officer of that body corporate, the person can also be liable, for the offense of issuing a dot check. Be it secretary, servant, agent, of the body corporate, as well as even the body corporate too. Both is a company or whatever, both the company and the person, the officials of the company who connive or who are negligent in issuing this check will be in for it. All of them will be guilty, and they might be prosecuted in the same manner as you're prosecuting an individual. Remember, I earlier told you that for an individual, the person will be sentenced to 2 years imprisonment without option of fine. Yes. Now that with respect to the involvement of officials of the body corporate and suing them all together, that's under section 2 of the Dishonored Checks Offences Act. It covers that in as much as it's a company or a corporate body that issued that check, and any other person, any other official who connived, who is negligent in the act of issuing this check, all can be prosecuted against. Now, for an offender under this act, the person will be tried summarily, yeah, by the High Court of the state where the offense is committed, and both the state attorney general and the federal attorney general, they have the power to prosecute any offender under this act. So it means that it's the High Court that has jurisdiction over this issue. But that doesn't mean that, because cases where I've seen cases where you know issue of police, when someone is owing you, go to the police, the issue of maybe there is fraud, or maybe they say when someone has obtained by false pretense and maybe the person is charged to court. I've seen where people relied on this case, on this act, on this law, to also secure the secure judgment, or to get the person, convicted. These things are intertwined depending on the situation. You know that when someone issues a check, a whole lot has happened. The person has defrauded you. That is, the person has obtained the goods or services you rendered by false pretense. That's a crime on its own. So that the person, someone issued you, it's just a one stream that has several parts. Because the person is liable for obtaining by false pretense, because it was under false pretense that this person is capable of paying, and the person can pay me that you supply the goods. And the person, okay, supply the goods, or maybe a part payment was given to you and you supplied way over the part payment so much and they're expecting your pay. And at the end of the day, you were given a check and there's this representation that this is your money. And you now go to the bank and they're telling you there's insufficient funds. The person has obtained your goods or your services under false pretense. And also the person has that false misrepresentation of fact that I will have money or I have money to pay you. And at the end of the day, it was a lie. And now then issuing of a Dud check. So it's more like committing 3 offenses in one. So the issuance of Dud check really does not really stand on it, because it cuts across a lot, depending on the one you want to pursue. Now, for the prosecution, what are they going to prove in court? You have now charged this person to court for issuing a Dud check. What are you going to prove to the court? To sway the mind of the court to the fact that indeed this person issued a Dud check. Now, just like I earlier said about inducement and obtaining by false pretense, you have to prove, that this person who is the defendant obtained or induced the delivery of anything capable of being stolen to himself or any other person by means of a check. Here, he's trying to say that the defendant, who is the accused person now, who issued the check, obtained or induced you to deliver goods, or for you to do, render services to him, by, or to any other person. So there's issue of inducement and the issue of delivery of anything capable of being stolen. You deliver goods, you deliver the services, and all of that. Another thing, you have to also prove that the defendant obtained credit for himself or any other person by means of a check. There are circumstances where, most people will say, okay, I can't deliver without being paid, and a check is handed over to you and you deliver the goods with the hope that there is the check is valid, not just is valid, but there is money in the account of the drawer of the check. So at that time, you have delivered the goods. You have the check in your hand in exchange for your goods or in exchange for the services you've rendered. And at the end of the day, you get to the bank and, like story upon story, you see that the person has obtained credit for himself or any other person. You have to utilize whatever you have delivered or have given to him under the pretense of issuing you a check. Another thing, you have to prove that the check was dishonored on presentation on account of lack of funds or insufficient funds on the account of the drawer in the bank on which the check was drawn. You have to prove that the check was dishonored on presentation. In the bank that the check was done, not someone gave you a Zenith Bank check, you're going to Eco Bank. No, 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 no. You can prove that I went to Eco Bank or I went to Zenith Bank. That is the bank in which the drawer that is reflected on the check, and on presentation, I was informed that no money in this account, that's insufficient account, we can't pay you because there's insufficient funds. Revert to the owner of the check or the drawer of the check. So you have to prove that you went and presented this check and it was not honored. And the fact that the check was presented no later than 3 months after its date. The check was presented not later than 3 months after its date. That you presented this check at least within 3 months after its date and the same issue happened. And that the fact that the check was not countermanded by the drawer before its presentation for payment. This is another point you have to prove, that the check was not countermanded by the drawer before its presentation for payment. And the fact that on presentation of this check, that the drawer account of the check, presented to you that he had the capacity, he had sufficient funds. Just like I earlier said, someone can give you a check and say, please, I don't have money in the account for now. Present this check in 2 weeks' time. And in 2 weeks' time, you now went to, at least the person told you that this, I'm sure that money will hit the account in 2 weeks. Maybe just in the third week, you went to present the check and it was dishonored. At least you observed the timeline and you went. But the person has assured you that in 2 weeks' time, money will hit the account. So the person too is guilty of issuing a Dud check, But when someone gives you a check and told you, there's no money in that account, anytime, you should not even collect such a check. Yes, you should not collect such a check. So you have to improving in presenting the facts to the court and by evidence proving to the court that you had the reasonable belief that this person has sufficient funds, as the person presented to you. You presented a check and it was dishonored. The check was not countermanded by the person who issued the check, and the check was presented not later than 3 months after the date. And the person induced or obtained delivery of anything capable of being stolen, to himself or to any other person by means of a check. And the person has obtained credit for himself or any other person by means of a check. So these are what you need to present to the court to prove your case that this person issued a Dud check. Now, it's also important to know that a person who draws a check which is dishonored on the grounds stated above, which I've earlier stated, in settlement or of any obligation, or someone is owing in settlement of any, debt under an enforceable contract entered between the drawer and the person to whom the check was issued, shall be deemed to have obtained credit for himself by means of the check, notwithstanding that the time when the contract was entered into and the manner in which the obligation will be settled may not be specified. What this under this provision of the Act is saying is, peradventure, there was no time limit as to when payment will be made, but you have delivered the goods, you have rendered a service and you're supposed to be paid. And after you have delivered the goods, a check was presented to you for payment. There's this you have this belief that I'm collecting my money. So that there was no time for payment as specified in the contract does not mean that when a check was presented to you, you should not reject it or say, okay, because there was no time limits in the check in the contract, I should not collect the check. No. But in fact, someone has given you a check, there's this assumption that money is in the account to fund the check. Now, there are some exceptions. Now, under that section one of the act said if this person who issued a Dud check can prove to the satisfaction of the court and when he issued that check, he had reasonable belief, he thought, he believed that he had money, or he believed that the check would be honored, and it was presented not later than 3 months after the date of the on the check, you know, the courts will look at his defense. If the person is saying, at the time I gave you the check, I was of the opinion, I'm of the belief, I reasonably believe that this check ought to have been honored because I knew I had money, or I thought I knew I had, not even thought, I knew I had money in this account as at the time this check was presented. So coming to tell me that the check was not honored is a story for me, or I'm surprised. If there's evidence that this person had money in his account, but for one reason or the other, the bank refused to honor the check, that's a different ballgame. That's a defense for that person. Like I at the time, I had a reasonable belief that I had money in that account, and that the check will be honored. That could be a defense for this person. That's under section 1 sub 2b and 3 of the act. Remember, the act we're referring to is Dishonored Checks Offences Act. Yes? Dishonored Check Offences Act. If you've not heard about it, just go and look out for it. It's Cap D11, Volume 5 from the LFN 2004. So when people, I always advise people though, when you're running a business, I would say you should be so money conscious, but issue of payment must be well specified. Now, for depending on the nature of business you do, when someone issues a check to you, some people will say, I cannot release the goods until I cash the money. Fine, some people do that, and some people feel there's money, go and cash the check and all of that. If you don't want to be caught up with this issue of check wahala and all of that, insist on a transfer to your account or on cash payment. Because when someone issues a check to you and you go to the court, you go to the bank and it is dishonored, the whole process of going back and forth, arresting this person, charging this person to court, and all of that, because it's a crime. You have to reach the police or the attorney general can prosecute, just like I earlier said. It's not just what you have to, you have to get the police involved, arrest this person, and the person is charged to court. So the whole stress of all that can be avoided if you can tell your customers or people you do business with that delivery is subject to confirmation of payment. Yeah, most people do that. I can't release my goods until I confirm payment, because this issue of check has destroyed relationships, it has destroyed businesses, it has rendered some businesses, in a moribund state. It has, even from trusted friends, trusted colleagues, you know. So even with the internet banking, the prevalence of internet banking in our time, people can do transfer no matter how the amount. Yes, and transfer to you. So I am of the opinion, I suggest and I advise that issue of payment must be well spelled out, because the challenges of going through the route of charging this person to court and all of that is a bit cumbersome. And whereby if you have set up your business in a such a way that payment before delivery, it will save you the whole stress of issue of you give me a dot check, you did not give me a dot check, and all of that. Friends, this is where we're going to cut it short today. Thank you for always following Lawyers Info Hub. Please share this video, let your friends know about it. Um, click on the like button. If you've not subscribed, subscribe to this channel, support us. And I know that the content we share on this channel will help you in one way or the other. Some information we share, most people have not heard about it, or even if they've heard about it, they've not heard it in depth that way. So, friends, this is where I'll say goodbye. And for someone who is fond of issuing Dud check, this is a sound or a note of warning to you. Um, it's a criminal offense. It is a criminal offense. I can go in for it 2 years imprisonment, 2 year imprisonment. So stop issuing that check. If there's no money, you tell the person, I have no money. The fact you have drawn a check and have given to a person, the person has believed that you have money in that account and it was presented, you have already committed a crime, you have already committed an offense, and it is a criminal offense. Some people are in prison because of this issue. Some people are ex-convicts because of this issue. So anything that will put you in trouble, I think just stay away from it. Do the right thing. It's better you tell someone, I don't have money now. I'm going to pay you maybe two months time. And sometimes, please don't be pressurized into giving a postdated check. When you're pressurized into giving a postdated check, remember that you're likely to fall into this trap of issuing a Dud check. Because by the time you issue postdated check and the money doesn't hit the account, as at the time the person is supposed to withdraw the money, you're in for this. At no point should you be pressured to issue postdated check when you're not sure of the inflow of finance or the inflow of cash into that account. Because most times people are in the fix that they are forced to issue postdated check. As people are, as business or people, or depending on the situation where you find yourself, are pressurizing to issue postdated check. When there's trouble, you won't see them smile again. So don't be coerced into issuing postdated check for any transaction, especially when you're not sure of the money cash inflow into your account. When you're not sure that you'll be able to meet up with the expectation of that business, when you're not sure that you're going to, meet up with the demands or pay up as and when due. So don't put yourself in a mess because you want to satisfy someone else, or you want to, seem to be a good person. If you don't have the money, you don't have it. It's better you tell the person, I don't have, let me work towards paying you, that being pressurized into issuing a Dud check. So take care of yourself, stay safe. This is Lawyers Info Hub, your surest law blog, your surest law channel, ever ready to give you legal solutions as it comes. If you're going through any legal challenges, you can DM me, you can talk about it. If you should talk about any topic, I'm all here for you. Just a DM will sort it out. I want to see your comments, and your criticisms, if there's any. So take care of yourself. See you next time. Thank you very much.